I now welcome representatives from the National Justice Project and Jumbunna Institute for Indigenous Education and Research. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, could you each please state your full name and the capacity in which you appear? And Dr. Beaufils, can you hear us?
Yes,
you can.
Thank you.
Okay, I'll go to Professor Newhouse first.
Thank you. I'm George Newhouse. I'm the CEO of the National Justice Project, and I'll let Dr. Beaufils provide his details.
James Beaufils, Senior Researcher at Jumbunna Institute.
Excellent. Do you have an opening statement, Professor Newhouse? Over to you.
Thank you, Senators, for inviting us to speak today. I make this statement having spent decades fighting for improved conditions for people in detention and in prison. I'm hoping to cover lived experience, the lived experience of those in detention and prisons, and Dr. Beaufils will cover the data and his research. The issue of youth justice is critical to our nation's future, and the success of all our children is a source of hope for a better Australia and a better world. The children who come in contact with the police, child protection services and the legal system are our most vulnerable. One study found that 90% of children in Banksia Hill Youth Detention Centre in WA had a neuropsychological disorder. That's 90%. Instead of meeting their needs and supporting them and their families, First Nations children are disproportionately taken from their families and communities and then criminalised and punished, often brutally. Their vulnerabilities, which should be addressed with care, are instead systematically used to punish them even further, such as by the use of solitary confinement, which is a form of torture, particularly for people with anxiety or personality disorders. If a child has the misfortune to be incarcerated, they have no effective protections, no effective advocates, and they receive virtually no care. In most states, it's my observation that there is no therapeutic treatment provided to children, no disability support, no education, virtually no education, just brutality and punishment. Children in detention are treated as outcasts from society. They are systematically disbelieved, just as children in the care of religious orders and orphanages were in the past. The Royal Commission into Child Sexual Abuse described these organisations as total institutions because they controlled all aspects of a child's life, and they were not open or transparent, and there was no independent oversight. The youth justice system is a total institution. It's just as controlling and is just as abusive as religious orders once were. The rates of abuse and violence in youth detention and in child protection are frightening, but the total institutions deny the existence of abuse and violence and simply blame the children, the victims of the abuse. These organisations rally around their staff and their structures, using the law and spin to protect themselves and not the children. Just as the church once did. And I'll just make this final comment about total institutions. Unfortunately, the police and protective services unions actively contribute to these horrors by protecting their membership above the needs of children. Now, you've heard a lot today. There's been a lot of discussion today about inaction on closing the gap targets, the Coalition of Peaks recommendations and other reports. But what about the Royal Commission into Aboriginal Deaths in Custody recommendations handed down 35 years ago? They set out a way forward. You're complaining about the Coalition of Peaks, but 35 years ago, the roadmap forward was handed down by the Royal Commission, and they still haven't been implemented. I'm not going to recite the sections, but the Royal Commission made a recommendation 62 regarding young Aboriginal people in the juvenile justice system. It's worth reading. The Royal Commission recommended consultation with appropriate Aboriginal organisations to make use of the services of Aboriginal organisations and to consult with local Aboriginal organisations about implementation of policies. And they also recommended to establish an Aboriginal Justice Advisory Committee in each state to provide the state with information on the views of Aboriginal people. It recommended imprisonment as a last resort, that's recommendation 92, that governments legislate to enforce the principle that imprisonment should only be used as a sanction of last resort. Our governments have done exactly the opposite. It made recommendations about improving custodial healthcare, sections 127, recommendations, 127, 150, 151, 152 and others about Aboriginal health services providing care and psychological support to Aboriginal people in custody. There is much more there, and I'm not going to simply recite extracts from the Royal Commission. I'm happy to answer questions after Dr Beaufils has spoken.
Dr Beaufils.
Yuridimarang Mujigalan, Kiwindu, James Beaufils, Baladu, Gundagara Gipir, Yinjamara Nati, Mayambu, Narambang. Thanks for everyone for having me here. I want to acknowledge country. I'm coming from Wiradjuri country, and thank you for listening. The overrepresentation in terms of youth justice is not something new. However, in the last few years, in terms of supervision and detention, it has seemingly decreased over a period. More recently has increased specifically for First Nations young people. I would like to acknowledge Ani Pat's commentary around remand. I think remand is a very underutilised research area in terms of why young people are there, what is happening when they are on remand, the ability to, as Aunt said, seek health and assessment and what is happening in those prolonged periods of time on remand for our young people. Trends over the last few years have increased, specifically for young women. Less focus and funding specifically on our young women is cause for concern in terms of government funding around our young women, and what is happening is an area to draw attention to in terms of earlier. There was a discussion around what's happening in terms of early intervention and what's happening from the address from the Commissioner around we need to start earlier with our young people and engage them. And it's been seen that in terms of education systems and what Professor Newhouse was talking around in terms of institutionalising, these are colonial institutions where community and young people and families still and continue to feel unsafe, and why that is in those institutions needs to be addressed. Voices of community, we heard that there is evidence and there is research out there. However, attention has to be drawn to who's doing the research and who's providing the evidence. There are a lot of non-Indigenous people researching Indigenous or First Nations matters and understandings. However, is this coming from community addressing what is happening in those areas and stopping government cycles of funding is critical to allow continued improvement within communities. I think it's quite difficult with the cycles of government. We talk about ACCOs or we talk about Aboriginal agencies. It's quite difficult to perform to a level or a service when you are looking to continuing the funding and the longevity, and that funding and longevity is never established, and it is difficult to attain continued and decent funding. So I think there's a number of areas to look at. What's been said already covers a lot. The numbers aren't new. I think and feel in terms of remand, we're comparative, specifically in New South Wales, in terms of our First Nations young people on remand, and in terms of disproportionately our population. So why is that happening, and what is specifically happening within remand?
Okay, thank you very much. Senator Shoebridge.
Thanks both for your submissions. And again, look, I just want to credit the work Jumbunna and the National Justice Project have been doing over many years and how critically important it is. Professor Newhouse, the concept of a total institution that is effectively free from external restraints, tends to be unobserved and wants to retain that power to be unobserved and free from external constraints. It really came to the fore in the Royal Commission Against Institutional Abuse, where particularly church-run orphanages and other institutions were permitted to engage in decades of ongoing abuse. Is it really able to be translated into the child protection system?
I think it's a fair comparison. You're talking about, and thank you, Dr. Beaufils, for reminding me, we are talking about colonial institutions, so they instill fear in themselves, but the institutions run around themselves. Whenever there's a problem, it's not the staff who are the problem, it's only the children inside. If there's a riot, the children are evil. No one looks at the reason why there may have been a riot. These children have been locked up for 23 hours a day, denied basic education, denied healthcare, denied sport, the ability to run around, do anything that a normal child might do. And yet, through the use of the law, which may suppress names, may suppress identities, suppresses what happens, and the fact that very few independent people go into youth detention centres and are able to reveal what goes on, they are total institutions. These children are totally at the behest and beck and call of the guards. And children with severe anxiety, I've had cases ending up in suicide. I mean, a lot of the work we do at the National Justice Project, unfortunately, is in inquests. Children with suicide are locked up in solitary confinement, which makes their anxiety worse. So they either lie about what's going on to the guards and then take their own lives, or if they tell the guards what's going on, they get punished. Also, behavioural issues are punished, not dealt with by therapeutic care. There is no therapeutic care in youth detention. Can I just raise one point that came up in Auntie Pat's evidence, and that was about remand. A lot of the children that are in youth detention are on remand. And we heard at the Royal Commission into People with Disabilities that the authorities responsible for the children, say at Banksia Hill, they would not send a child on remand to a FASD assessment because they cost $8,000. And by the time they got an appointment, the child might be out. So we talk about properly assessing children. This is an opportunity to properly assess children and work out their circumstances, but medically. But they're not getting that opportunity if they're in remand.
Can I, sorry to interrupt there, with your indulgence, Senator Shoebridge, the FASD assessment?
Fetal alcohol syndrome disorder.
Okay.
Now, I think the President of the Children's Court in Western Australia has every child assessed for FASD, before they are sentenced. 36% of the children are diagnosed with fetal alcohol syndrome disorder. When they get into youth detention, they get no support. And once again, this total institution, no one cares. No one, if they complain, no one's listening. So it is a total institution, and it is abusive.
Yeah, Dr. Beaufils, do you have I suppose particularly from your work at Jumbunna, talking with First Nations communities, when they see their kids disappear into these institutions, Professor Newhouse calls them total institutions, which are free from external scrutiny, in total control of particularly in this case, the children in there. From Jumbunna's perspective, how do you respond to that?
So I can speak from my perspective. I can't speak for the entirety of Jumbunna, but within the research, I think when a young person or family is engaged with an institution, it is very difficult because in terms of the wording and language used, the issues are generally steeped or pushed onto the young person or their family, as in there is an issue, it's behavioural management, there is a need for change. They're not living to a specific standard. However, it's not understood what the pressures or constraints or parameters that are set upon that young person or the families or the situation that they're dealing with is fully understood. I think it is critical, as Anipat said and Professor Newhouse has reiterated, that time on remand needs to be effective. In terms of work currently underdone in a jurisdiction within Australia, what is happening with that remand process in terms of programs are not education. Education and improvement needs to be addressed of what specifically is happening for our young people within their learning and understanding when they are taken from community. In terms of the Banksia Hill example, the neuro psychology and what was happening with those people, this is a specific opportunity where the resources should realistically be there to assess or assist with that young person of what is happening and what has happened. And I think it is missed in terms of, from a disability framework or standpoint, what is happening for our young people? Is there something that has been overdiagnosed, misdiagnosed, or not even addressed or understood? Specific neurodivergencies, which I think are very underdone for our people, in terms of the ability to feel safe when going or addressing possible symptoms or understanding of that, what will happen in terms of child protection if our families are approaching these services in good faith to get that understanding. And these are the difficulties that we're facing in terms of the funding and assessment and longevity of this, and the possibility of this would better be suited within communities.
Yeah, thanks, Doctor. To one or both of you, one of the matters covered in your submission is about Banksia Hill, and I suppose when we're talking about Banksia Hill, which is a Western Australian child prison, we also need to talk about Unit 18, which is a unit in an adult prison, a nearby adult prison in WA, where kids were sent who should have been, well, if they were held in detention in a child prison, were sent into an adult prison because of the appalling conditions in Banksia Hill. Can you talk us through some of the failed accountability measures in WA? Because there's been independent reports, there's been Supreme Court decisions, there's been multiple ringing of the bell about the torture-like and appalling conditions in those two facilities, and yet the WA government persists. Can you talk us through that?
Doctor, are you happy for me to cover that issue, or would you like to?
I can just start on that. I think within those circumstances with WA, I think within remand, the number of young people that are on remand in those situations is quite high and dramatically high. I think remand should be philosophically kept for the most extreme circumstances, yet it's not. The presumption, and I put it to the panel, that the presumption should be in the favour of the bail to support the community and the child and the family. However, that is not happening, and the larger numbers are increasing. And the use of the services is because there is an increase in what's happening in terms of our young people getting picked up, misunderstood, or not thoroughly investigated, or this understanding isn't there. And there's a swell of our people going into these colonial institutions who aren't looked after, who, as Professor Newhouse has said, who are continued in terms of the trauma or re-traumatised or abused, possibly. And why is this happening? Was it for an extreme circumstance or the most extreme circumstance that they were put in there? That's not what we're seeing. And when we're talking about our young people, how is this the case? Professor?
Yeah, thank you. I want to take up one of the points that doctors raised. It costs $3,000. The Productivity Commission found just last week it costs $3,300 a day to house one of these children. Can you imagine? You could put them up at the Hilton in Perth for that amount, but because there isn't bail housing in WA, or there's no one that can receive these children, they are going into prison at a cost of over $1 million a year. Surely we can do better than that. You ask why not? I think there's probably two reasons. First of all, in WA, they don't want to spend the money on alternative solutions and supports for children to divert them away from the prison system and the youth detention system. Yes, it costs money, but when you work out $3,000 a day to have them in there, there's got to be a saving to the community by diverting children. It was one of the recommendations of the Royal Commission into Aboriginal deaths in custody, and we must see more of that. And also, before he retired or resigned, the former Premier of WA, just in the weeks before he retired, described these children as hardened criminals. There is a prejudiced attitude over in WA about these children. They need support, they need diversion, they need housing, they need healthcare and education, not punishment. So I think there's a punish now attitude, and they're not listening.
But, I mean, it isn't as though this was unobserved. In this case, the Supreme Court, I think, when it comes to Banksia Hill and Unit 19, there was a finding in the middle of 2023 by the WA Supreme Court that 3 children at Banksia Hill and Unit 18 were subjected to a total of 167 days of unlawful solitary confinement. Mm-hmm. And that was just that 3-month period they looked at between September and December 2022. And 1 child was held in solitary confinement for 133 days. There was an injunction granted to try and prevent that from happening. But the WA government largely has ignored the Supreme Court. Banksia Hill and Unit 19 continue. Solitary detention is still being used. This lack of accountability is one of the extreme case studies, isn't it?
Yes. Look, I can actually speak from experience. I ran a case against the movement of children into an adult prison in 2012 in WA, and the Supreme Court there were reluctant to interfere because there was no other place in WA that they said that children could go. So I've been fighting this fight for over a decade. You also mentioned children being locked up for 167 days. I'm fighting for 2 children that were locked up for 365 days in solitary confinement. The government of Western Australia has been fighting for 5 years. They're using every tactic in the book to delay. They do not want the public. This is part of the total institution. They don't want the public to know what happened to these children, and they will fight tooth and nail to defend themselves. But a Supreme Court judge, as you rightly pointed out, has already found that method of holding children in solitary unlawful. They will lose in the end, but they will fight for years to hide the horrors of what's going on in that institution.
So when we have a state government, in this case, not even complying with its own laws, being found to be in breach by its own Supreme Court, and then ignoring the rulings of the court, maintaining these abusive institutions, do we just at a Commonwealth level say, oh, well, it's a state matter, we'll leave it to the states? Because that's what the Attorney General's submission says. Oh, well, it's a state matter. That seems to me to be a betrayal of WA kids, which are Australian kids as much as they're WA kids. Doctor, do you have a view on that?
I think it comes down to, and there's been a lot of analogy used around glue, and what is this glue to hold X and Y together, or to improve child protection, or to improve youth justice. What is that glue? I think it really does come down to the accessibility and assistance in accessing funding for community organisations, assessment groups, whether that be for what we talked about in terms of accessing these institutions when on remand, funding to that in a longevity of that to allow communities to assist their young people and to assist themselves. Again, in terms of the glue and the evidence should be from communities. There's an incredible example of within child protection around the Menaditja care model, a community caring for their young people in child protection. That's a research project that's come through Jumbunna that has been incredibly well received. Additionally, in terms of what's happening in other jurisdictions, the ability to engage or to have engagement with detention centres and the ability to access them by community, they are seen to be in and of themselves, which again is unapproachable, not able to engage or access the young people of what's actually happening. Why that is needs to be addressed. And it needs to be understood around how to go about the access and understanding. So I think the idea of the glue, it is coming from communities and having that funding over a period of time rather than a 4-year cycle. And I think there has to be some accountability, as you say. So, you look at the end of last year with other jurisdictions and what was happening in terms of within politics or the political realm. You have this media hysteria around young people. You have this understanding that people or communities are not safe. You're talking about the increase in stolen cars, assaults. They're increasing by 282%. However, what's actually happening for those young people? What's happening for the funding within those communities to allow those young people to not possibly commit or be a part of because of boredom or necessity? What's happening with that? So there's not a lot spoken about either side. I think there needs to be the accountability as to if someone's going to say something for a political purpose, what's happening on the other end. And in terms of the racialising, then it does come down to either black or brown or youth gains is the wording that would be used. And why are they allowed to put this out there with little retort from those young people or communities who they're focusing that on?
Well, talking about the lack of accountability, I'll go back to just this one abusive institution, 2 Banksia in Unit 18. 3 months after the Supreme Court handed down its decision about torture-like conditions in those institutions, we had the tragic death of Cleveland Dodd, who took his life in a prison cell, a badly damaged, inappropriate prison cell in Unit 18. 3 months after the Supreme Court handed down its rulings, which the state government did nothing to implement, we then have the tragic loss of Cleveland Dodd's life, obscenely foreseeable that those circumstances would lead to that kind of loss. And then 9 months later, after a behind closed doors investigation by the state's Corruption and Crime Commission, they hand down a report saying nothing to see here. No recommendations, nothing to see here into Cleveland Dodd's death, tragic death. Is that the definition of a total institution, Professor Newhouse? Is that kind of one in action?
Yep. It's a protection racket. Unfortunately, the systems that, and Dr. Beaufils wants to answer this too, but I'll just answer your question. All the systems within the state are designed to protect that institution. That is a total institution. And the government are free to get away with it. I'll hand over to you, Doctor. You've had your hand up.
Yeah, no, thank you. I think, as you said, in terms of federal government, how they should sit, it should always be the role for the federal government in their matters. this is a federal government that signs up to human rights instruments that are actively or available to be used. The states are, if the states aren't complying, then yes, the federal government should exert any influence it can to ensure these states and territories are complying with their human rights responsibilities. And it was said quite well from the National Children's Commissioner, Anne Hollands, in terms of if they're not addressing them, then what is actually happening in terms of the Help Way Earlier project.
If we were going to look for a blueprint to fix this broken federal model where kids just keep falling through the cracks between states and territories and the Commonwealth, is that where we look for a blueprint, the Help Way Earlier, Doctor?
I think it's quite hard when someone's looking for a blueprint or when someone's going to look for glue. I mean, it's very difficult to, if I was to provide you with a blueprint, your interpretation from your own standpoint. I think it does come down to these communities and their ability to understand and be actively, but also drivers or self-determining of what's happening within this. I mean, there are, and people keep saying, and we have heard that, there is evidence and research. However, if we look critically at it, that evidence and research or blueprint construction or glue manufacturing is not coming from our communities who are the people who are under-resourced and underfunded and underserved.
Well, pretty much all the recommendations say fund, invest in and empower those communities. Don't impose your solution and get the community to implement it, but fund, invest and empower in those communities themselves. Is that a way of looking at the glue?
It could be. And, you know, I think in terms of what Ms Gordon was saying previously and how things in terms of evidence and research and things should be happening, you know, we've had 200 odd years of colonialism and it's not working. So things do take time, and being understanding of that within the communities and allowing that slow going if necessary. You know, the situation really can't get much worse, but it probably will if we continue on this trajectory.
Well, it turns out that some things don't take time. Queensland rushed through an aggressive patch of laws that wound back children's rights. They suspended their own Human Rights Act. They did that in a matter of weeks. That didn't take time. Doesn't take time to take away kids' rights or to put kids in prison, yet it always seems to take decades to try and do the opposite. Should we be learning from our opponents in this regard and demanding rapid action?
I see where you're going, and I completely agree in terms of, you know, within New South Wales, in terms of guardianship orders, they got pushed through at a rapid rate. And I know you were one of the persons that did stand to that in terms of the guardianship, yet that went through quite swiftly. However, we're looking at interest. We're not looking at First Nations interest in either of those examples that you're talking about, whether it be Queensland or whether it be New South Wales. So how is this to act swiftly? You know, I do put it to having people like Little sitting on this at the moment and engaging and having access for First Nations communities at senior levels to have the say and to be heard and to come from communities and talk about experience and be funded and invested for that.
Well, I mean, just last year we had this theatre that illustrates how little states and territories are willing to listen, even to voices they established in Queensland. Literally, as the Queensland Parliament was passing its laws, suspending the Human Rights Act, reversing presumptions for bail against kids, putting in place that suite of packages that has led to more First Nations kids going into jail, literally at the same time, we had the Eric D. Rule Youth Parliament, 42 First Nations kids in the adjoining chamber debating what they saw as a youth justice package of reforms that would actually work and coming up with their own answers. And at the exact same time, the Queensland government legislated the total opposite package in the chamber next door. I suppose, Professor and Doctor, you know, when you have the answers being given in one chamber and then the exact opposite being done right next door, how can we trust state and territory governments?
Well, you raise a good point. And the state and territory governments are failing children, but they're particularly failing First Nations children. And maybe it is time for the federal government to use their powers, either the race power or the treaty's power. You know, we're signed up to the Convention of the Right to the Child to actually pass laws to set minimum standards, to engage with local communities and save these children from the abuse that they're experiencing. It's just appalling. They know what there's, as you heard Auntie Pat say, there's evidence-based solutions, but they are being ignored for get tough on crime.
Senator Shibridge, I've got a few questions. We're right at the end of our time.
I'd put Auntie Pat in charge, by the way, just for the record. But,
okay, thank you. Professor Newhouse, you mentioned in relation to fetal alcohol syndrome disorder, one particular agency that didn't want to send someone to a FASD assessment because it would cost $8,000 and that child was on remand. Can you just, who was that? Which agency was that? And what's the thinking? What's the twisted thinking that leads to that?
That was evidence that it's freely available to the Royal Commission into people with disabilities.
Right.
It was I think it was the superintendent of Banksia Hill Prison. So he would be employed by the Department of Corrective Services in WA. And they were saying, I don't know whether it was financial. I think their constraints were financial and also temporal. Oh, we've only got these kids for a short time. It's not worth it, was essentially the nub of the evidence. And the Royal Commission was quite critical of that too. But it was interesting to hear it vocalised. So that was evidence given to the Royal Commission.
Because isn't it I would have thought if you have the opportunity to undertake perhaps not even just a FASD assessment, but a holistic assessment of someone's health, both mental and physical, to look at the family unit and see what's happening there, you should take advantage of that at the first opportunity. That's what common sense would indicate to me.
Me too, Senator. But look, there is one thing that I'd like you to understand. I see Mr McIntyre speaking next. Mr McIntyre's a barrister who's represented many First Nations families at inquests. When we look at what happens to children after they die in custody, you realise how shockingly appalling the level of care is. On any day, there is a risk assessment about whether that child is going to kill themselves. And if they're not going to kill themselves, they're left to their own devices. There is really no ongoing assessment, therapeutic care, all the things that you were just talking about. Let's look at their home environment. Let's look at their education. Dr. Beaufils raised that. Let's look at their situation, try and understand it, and support them when they leave. None of that happens. And yet we spend $3,000 a day on them.
Well, I was $3,300 a day, I think you said, was the latest figures, which aggregates to approximately 1.2 million a year for each child in detention. And that's only part of the equation, isn't it? I mean, each human being has their own innate value as a human being, their own potential to be realised, but also the difference between having a productive member of society from a society point of view who's developed skills, contributing to society, raising their own family in a safe environment. The 1.2 million a year is only part of the equation, isn't it?
That's right. And look, the statistics, the evidence shows that providing that level of support, particularly post-release, can reduce recidivism by 60%.
Yeah.
We need to support these young people. They are our future, and we're not. We're failing them. They come out worse than they go in, and the impact is multi-generational.
And my last question is just on this issue of remand. What are the driving factors behind that? Is one that the justice system itself is under-resourced, or what are the driving factors behind, in particular, children spending such long periods in remand?
I have some, but Doctor, do you want to answer that first, or?
I just think on that as well. Children aren't being properly assessed within these institutions as well, whether that be out-of-home care or juvenile justice. They're scrambling to get these assessments done. However, if communities were available and assisted too within their own resourcing and by their own people to have these done and provide these and engage with these services, this may have been mitigated. However, it's not happening and the children are already in crisis. And so when it is coming to the remand, it's a number of issues and a number of reasons. A lot can stem from bail law reforms or lack of information within and of those young people. So we're not doing the work and we're not triaging once it's at that critical point. We're holding, and they are holding positions for our people that aren't receiving the support necessary.
Yeah, I'll just agree with that. The bail laws are shifting the burden onto the children so that it's more difficult to get bail. Second of all, lack of housing, lack of bail hostels, lack of places for these children to go to is an issue.
Okay, understood. Okay, thank you very much for your evidence, and thank you for all the work you do. It's greatly appreciated.
Thanks, Senator.